Warm greetings, friends. I'm Dr. Pawandeep Kaur from Khalsa College of Law, Amritsar. The topic of our today's talk is development of legal system in India. Dear students, the present module talks about the development of legal system in India. I have divided this module into three parts. In the first part of this module, we will discuss the meaning and brief historical perspective of legal system in India. In the second part of this module, we will discuss the development of legal system in British India. In this part, we will elaborate the early settlements of the East India Company and establishment and evolution of the courts. This part will also highlight about codification of laws in India. In the third part of this module, we will talk about development of legal system after independence and constitutional era of the legal system in India. So, dear friends, I would like to start today's talk by quoting Martin Luther King, as he said very well that law and order exist for the purpose of establishing justice, and when they fail in this purpose, they become the dangerously structured dams that block the flow of social progress. Dear friends, one of the most worst legal systems in the whole of human history is the Indian legal system. From time immemorial, the lives of the native people were guided by the native laws, which varied from time to time and place to place. In the absence of a nation state, in its true spirit, there was no surprise to find the non-existence of a codified legal system applicable to the whole subcontinent. The ancient Indian system transformed into medieval and from medieval to modern with the changing times. Our contemporary legal system is grounded on British laws. India, one of the most primeval civilized systems in the world, by its affiliation to the Indus Valley civilization, followed the decrees of kings who ruled India as per their own personal or religious laws. The concept of nyaya, justice, finds a mention and in-depth explanation in ancient Indian scriptures. One such ancient Indian scripture is the Nyaya Sutras, which were probably composed around the 2nd century before Christ by Akshta Gautam. There were 4 core themes of the Nyaya Sutras. These are examinations of opposed views, the art of debate, means of valid knowledge, and syllogism. These ancient traditions and developments have given grounds for the present legal system. India's rich and complex legal heritage indeed reflects a long history of adaptation and evolution. The Indus Valley civilization, one of the earliest urban cultures in the world, had its system of governance and trade, which laid foundational elements for later legal structures. India's first major civilization flourished around 2500 before Christ in the Indus River Valley. This civilization, which continued for 1000 years and is known as Harappan culture, appears to have been the culmination of thousands of years of settlement. For many thousands of years, India's social and religious structures have withstood invasions, famines, religious persecutions, political upheavals, and many other cataclysms. Few other countries have national identities with such a long and vibrant history. The roots of present-day human institutions lie deeply buried in the past. This is also true about the country's law and legal system. The legal system of a country at any given time cannot be said to be the creation of one man for one day. It represents the cumulative effect of the endeavor, experience, thoughtful planning, and patient labor of a large number of people throughout generations. The modern judicial system in India started to take shape with the control of the British in India during the 17th century. The British Empire continued till 1947, and the present judicial system in India owes much to the judicial system developed during the time of the British. India boasts one of the world's oldest legal systems. Centuries of history have left a legacy of law and jurisprudence that has developed and changed alongside the diverse population. Dear friends, moving further, now we will discuss the historical perspective of legal system in India. The development of the legal system in India is a fascinating journey through history, reflecting the country's evolution from ancient times to the present. An analysis of Indian legal history reveals the existence of several legal systems that have coexisted in India over time. Furthermore, in contrast to what is often believed in the West, several modern ideas of law existed in comparable forms in India before the medieval era. The British tried to re-establish law and legal institutions for the Indians, mostly disregarding their legal customs. This was a component of a bigger attempt to provide an ideological justification for the British Raj's rule over India. The British established British common law as the supreme law of the kingdom by citing India's existing legal variety as evidence of the absence of a dominant legal tradition. Dear friends, it is pertinent to know about legal system in ancient period. During this period, the legal system in India was deeply rooted in religious and customary laws. Overall, the Hindu period's legal system was deeply rooted in religious and customary law, with a focus on maintaining dharma and social order through a combination of divine principles and practical administration. It is believed that Hindu law is a divine law. It was revealed to the people by God through Vedas. Various sages have expounded and refined the conceptual ideas of life mentioned and explained in the Vedas. Friends, now I would like to put light upon legal system in Vedic period. The classical legal system of Hinduism was distinct from modern law because it adhered to a particular value system and distinctive structure of law and governance. In terms of legal theory and practice, ancient India represented a unique legal tradition with a historically separate school. During the Vedic era, upholding dharma or duty and righteousness was the primary goal of the legal system. Legal obligations and religious obligations make up dharma, a vast range of human activities, including as ritual purification, personal cleanliness, regimens, and dress codes are encompassed in it, in addition to laws and court proceedings. The primary inspiration one sought to follow in living was given by dharma. The sources of law during this period were Shruti, Samriti, and Achars, also known as customs. Shruti consists of four Vedas, namely Rig Veda, Yajur Veda, Sam Veda, and Athar Veda. These Vedas chiefly dealt with religious duties, practices, and customs. The second source is called Samritis, which means as remembered and refers to the tradition. They are the humanly authored written texts that contain the collected traditions. Some of the most prominent Samriti are Dharmashastras and Dharmshutras. Moving further, we will discuss the legal system in medieval period. The medieval period in India witnessed the development of a diverse legal landscape influenced by regional kingdoms, Islamic law under the Delhi Sultanate and Mughal Empire, and the later British colonial interventions. The integration of various legal traditions and the introduction of new administrative practices during this era significantly shaped the evolution of India's legal system. The medieval period in India, spanning from roughly the 7th to the 18th century, saw significant developments in the legal system influenced by the rise and fall of various dynasties and empires. Dear friends, the legal system in the medieval period has been divided into two parts. The first one is early medieval period and second one is the late medieval period. First we will discuss early medieval period. Regional kingdoms and local practices. During this time, India was divided into numerous regional kingdoms and empires, each with its local customs and legal practices. The influence of regional rulers led to a variety of legal systems tailored to local needs. The legal principles from the Dharmashastras continue to influence legal practices, especially in regions under Hindu rule. Local customs and practices often supplemented these ancient texts. The establishment of the Delhi Sultanate marked the introduction of Islamic law, Sharia, into the Indian subcontinent. The rulers such as Qutbuddin Aibak and Alauddin Khilji incorporated Sharia principles alongside existing local customs. The Sultanate introduced new administrative structures, including the establishment of separate judicial offices and the integration of the Islamic legal principles with existing systems. Mughal period, Emperor Akbar made significant reforms by integrating Islamic law with local Hindu customs. He established a more centralized legal system and sought to harmonize various legal traditions. The Mughals implemented a centralized legal system with a hierarchy of courts. The emperor was the ultimate judicial authority, and regional governors had judicial powers in their areas. Islamic judicial officers such as qazis and muftis were responsible for adjudicating cases based on Sharia and local customs. The Mughal emperor codified various laws and procedures combining Islamic legal principles with local practices. These codes were adapted to address issues such as property rights, criminal offenses, and family law. Further, British colonial influence, that is late medieval period. By the late 17th and early 18th centuries, the decline of Mughal power led to the increased influence of the regional powers and the eventual rise of British colonial rule. The British East India Company introduced its legal system, which combined British laws with existing Indian practices. Key reforms including the codification laws and the establishment of formal judicial systems. A charter given by King George I in 1726 to bring about significant reforms to the judicial administration of the presidency towns of Bombay, Calcutta, and Madras is where the history of current judicial systems begins. This charter established the appeals process from India to the Privy Council of England in 1726. The king enacted the East India Company Regulating Act of 1773 to improve the management of East India Company's operations. This act placed the East India Company under the jurisdiction of the British government and provided for the establishment of the Supreme Court of Judicature at Fort William in Calcutta by His Majesty through charter or letters patent, replacing the existing legal system. On 26 March 1774, a letter patent established the Supreme Court of Judicature in Fort William. This court, being a court of record, possessed complete jurisdiction and power to consider, hear, and rule upon any charges brought against any of His Majesty's subjects for any offense. Dear friends, now we will discuss the development of legal system in British India. The Indian legal system has a rich historical background that has been shaped throughout the ages by a variety of legal systems. With codified laws like the Manusmritis, which handled civil and criminal concerns based on Hindu principles. Ancient India had a well developed legal system. With the establishment of Muslim rule, Islamic law gained prominence, particularly during the Mughal Empire when Sharia law dominated many facets of Muslim society. The time of British colonization saw the biggest transformation. Modern Indian jurisprudence was founded upon the common law system that the British established. During this time, significant contributions were made to the creation of the Indian Penal Code 1860, the Indian Evidence Act 1872, and the Civil Procedure Code 1908. These codifications replaced a plethora of regional laws and customs, bringing uniformity and clarity to the legal system. Moving further, the British East India Company's early settlement at Surat and its administration. Dear friends, the early settlement at Surat was a significant movement in the history of British colonial expansion in India. Surat, a major port city on the western coast of India in the Gujarat region, became a key location for the British East India Company in the early 17th century. The British East India Company's first successful venture into Surat was in 1608 when Captain William Hawkins arrived there. Hawkins was sent by the company to establish trading relations with the Mughal Empire. The Mughal Emperor Jahangir granted the company permission to trade in Surat. This agreement marked the beginning of the significant commercial relationship between the British and the Mughal Empire. The administration of Surat was primarily under the control of Mughal authorities. The East India Company operated under Mughal laws and regulations but had a degree of autonomy in managing its affairs. The administration of company's affairs in Surat was handled by company officials, including the president of Surat factory, who was the chief representative of the company in the city. The company's officials in Surat were responsible for managing trade operations, resolving disputes, and ensuring compliances with the terms of the trading agreements with the Mughal Empire. The company had to navigate complex relationships with local Mughal officials, merchants, and other European competitors. Diplomacy and negotiation were crucial aspects of managing these interactions. The success of the Surat settlement laid the groundwork for further British expansion in India. Surat became a base for future operations and paved the way for the establishment of more trading posts and settlement along the Indian coast. The early settlement at Surat was a critical development in the East India Company's efforts to establish a foothold in India. The settlement provided a crucial base for trade and administration, and experiences gained there helped shape the company's approach to managing its affairs in the region. Moving further, now we will discuss the establishment and evolution of courts. Dear friends, the establishment and evolution of courts in India reflect the country's legal and political history, transitioning from colonial system to an independent sovereign state. Before British rule, India had a diverse array of legal systems, including Mughal courts and the regional princely courts. These courts were based on Islamic law, local customs, and traditional practices. Early British settlements, such as those in Surat, Madras, Bombay, and Calcutta, had ad hoc judicial arrangements. These included makeshift courts led by company officials who addressed disputes and administered justice informally. Charter of 1726 established municipal corporations in Madras, Bombay, and Calcutta, creating formal mayor's courts to handle legal matters. In 1774, the British Parliament established the Supreme Court of Calcutta, followed by similar courts in Bombay and Madras. These courts had jurisdiction over serious criminal and civil cases involving Europeans. Sadar Diwani Adalat and Sadar Nizamat Adalat were established in the early 19th century to handle civil and criminal appeals, respectively, in the Bengal Presidency. Dear friends, moving further, now I would like to put a light upon the codification of law. The development of codification of laws in India was a significant aspect of the British colonial legal system, aimed at creating a uniform and systematic legal framework. Codification efforts introduced during British rule laid the foundation for modern Indian law. Before British rule, India had a diverse array of legal systems based on regional customs, religious laws like Hindu, Islamic laws, and local practices. The British East India Company initially operated under a mix of these traditional laws. As the British administration expanded, there was a growing need for a uniform legal system that could apply consistently across British India. During the British colonial era in India, the codification of Hindu and Muslim law was a significant aspect of legal reform. The British sought to systematize and standardize legal practices for various communities while also integrating these practices into the broader framework of British law. Dear friends, here is an overview of how Hindu and Muslim laws were codified during the British era. Codification of personal laws, Hindu Law of Inheritance Act 1925, Hindu Marriage Act 1955, Muslim Personal Law Shariat Application Act 1937, Muslim Marriage Act 1939, further, codification of civil and criminal laws. Indian Penal Code 1860, Criminal Procedure Code 1861 and 1973, Indian Evidence Act 1872, Code of Civil Procedure 1908, and the last one was the Indian Contract Act 1908. Dear friends, at the last but not the least, now we will discuss the development of legal system in independent India. The development of the Indian legal system after independence in 1947 has been marked by significant reforms, codification of laws, and the establishment of new legal institutions. The aim has been to create a robust and comprehensive legal framework that addresses contemporary issues while respecting the diverse and democratic nature of the Indian state. Here is an overview of the key developments in the Indian legal system since independence. The first one is the Constitution of India. The Constitution of India came into effect on January 26, 1950, establishing India as a sovereign, socialist, secular, democratic, and republic state. Further, codification of laws, Indian Penal Code 1860 and Criminal Procedure Code 1973. The Indian Penal Code and Criminal Procedure Code were retained from the British era but have been periodically amended to address new types of crime and improve procedural efficiency. Dear friends, it is important to note that the criminal legal framework in India has a substantial transformation with the impending implementation of the Bharatiya Nagrik Suraksha Sanhita 2023, Bharatiya Nyay Sanhita 2023 and Bharatiya Sakshya Adhiniyam 2023. These acts replace the Code of Criminal Procedure, Indian Penal Code and Evidence Act respectively, signify a monumental shift in the country's legal architecture. Civil Procedure Code 1908. The Civil Procedure Code has also undergone amendments to enhance the efficiency of civil litigation and address contemporary issues. Dear students, there is a list of key legal reforms and legislation. First one is Hindu Marriage Act 1955 and Hindu Succession Act 1956. Second is Muslim Personal Laws Shariat Application Act 1937 and subsequent amendments. Third one is Protection of Human Rights Act 1993. Fourth one is the Right to Information Act 2005. And fifth one is Goods and Services Tax Act. It is also known as GST Act 2017. And last one is Jammu and Kashmir Reorganization Act 2019. Since independence, India's legal system has evolved to address the needs of diverse and rapidly changing society. Key developments include the adoption of constitution, codification and reform of laws, establishment of specialized courts, expansion of legal education, and ongoing reforms to enhance the effectiveness of the judiciary. These changes aim to uphold democratic values, ensure justice, and adapt to contemporary challenges in India's legal landscape. Dear friends, now I would like to end today's talk by saying that history comprises the growth, evolution, and development of the legal system in the country and sets forth the historical process whereby a legal system has come to be what it is over time. The legal system of a country at a given time is not the creation of one man or of one day, but it is a cumulative fruit of the endeavor, experiences, thoughtful planning, and patience labor of a large number of people through generations. With the coming of British to Indian legal system of India changed from what it was in the Mughal period, where mainly the Islamic law was followed. Before that, the Hindu laws were followed. The legal system currently in India bears a very close resemblance to what the British left with us. So, dear friends, this is all about today's discussion. See you in the next module. Have a nice day. Thank you so much.